So today we're talking about the process in which a confiscation order is made under the Proceeds of Crime Act 2002. Essentially, what happens first is that a timetable is set when somebody is sentenced for the substantive or main offence, and it's a three-stage process with a hearing at the end of it. So the first stage is what's called a Section 18 statement, and the defendant produces a list of all their assets, which includes bank statements, bank accounts, property, cars, or any other items of value that they have. That is then forwarded to the prosecution. And the prosecution then respond with what's called a Section 16 statement, in which they set out the argument for the benefit figure that they say the defendant has made from the crime and or criminal activity, and also suggest what available amount the person has to pay towards that figure. The defence can then respond to that Section 16 statement with a Section 17 statement, in which they consider the prosecution's submissions and respond to them. And they can either agree to the prosecution's submissions if they agree with some aspects of what they say, or they can dispute them. And if there are any figures to be disputed, then there should be an argument setting out why. And the clearer the argument, the more likely success is going to have. Finally, there is a hearing, and the vast majority of the hearings are agreed beforehand, and if they are agreed beforehand with the benefit figure agreed and the available assets agreed, then a judge essentially rubber stamps the figures and the confiscation order is made. If there is any dispute about anything in relation to the different figures, then a judge can ultimately make the final decision in relation to the area of dispute, having heard evidence from both sides.